First of all, today I want to make it clear that the historical background of Indian Constitution के संदर्भ में मैं आपको जो ही बातें आपके सामने ला रहा हूँ वो एक बहुत बड़े लेखक थे उनके किताब से लेकर मैं आ रहा हूँ, उनकी लिखी पुस्तक से लेकर मैं आ रहा हूँ. दिस इज सेकेंड पार्ट ऑफ द वीडियो ऑफ द हिस्टोरिकल background of Indian Constitution, which is as follows. The reform of 1919, however, failed to fulfill the aspiration of people in India and led to an agitation by the Congress then under the leadership of Mahatma Gandhi for Swaraj or self-government independent of the British Empire to be attained through non-cooperation. The shortcomings of the 1919 system mainly were, notwithstanding a substantial measure of devolution of power to the provinces, and the structure still remained unitary and centralized, with the Governor General in Council as the keystone of the whole constitutional edifice. And it is through the Governor General in Council that the Secretary of State and ultimately Parliament discharge their responsibilities for the peace. Responsibilities for the peace, order and good government of India. It was the Governor General and not the courts who had the authority to decide whether a particular subject was central or provincial. The provincial legislature could not, without the previous sanction of the Governor General, take up for consideration any bill relating to a number of subjects. Second, the greatest dissatisfaction came from the working of diarchy in provincial sphere. In a large measure, the governor came to dominate ministerial policy by means of his overriding financial powers and control over the official block in the legislature. In practice, scarcely any question of importance could arise without affecting one or more of the reserved departments. The impracticability of the division of the administration into two watertight compartments were manifested beyond doubts. The main defect of the system from the Indian standpoint was the control of the purse. Finance, being a reserved subject, was placed in charge of a member of the Executive Council and not the minister. It was impossible for any minister to implement any progressive measure for want of funds, and together with this was the further fact that the members of the Indian civil service, whom the ministers were to implement their policies, were recruited by the Secretary of State and were responsible to him for him and not to the ministers. Above all was the overriding power of the governor, who did not act as a constitutional head even with respect to the transferred subjects. There was no provision for collective responsibility of the ministers to the provincial legislature. The ministers were appointed individually, acted as advisors of the governor, and differed from members of the Executive Council only in fact that they were non-officials. The governor has the discretion to act otherwise than in accordance with the advice of his ministers. He could certify a grant refused by the legislature or a bill rejected by it if it was regarded by him as essential for the due discharge of his responsibilities relating to a reserved subject. It is no wonder, therefore, that the introduction of ministerial government over a part of the provincial sphere proved ineffective and failed to satisfy Indian aspirations. The persistent demand for further reforms, attended with the dislocation caused by the non-cooperation movement, led the British government in 1927 to appoint a statutory commission as envisaged by the Government of India Act 1919 itself. Section 84A to inquire into the report on working of the Act, and in 1929 to announce the Dominion status was the goal of Indian political developments. The commission headed by Sir John Simon reported in 1930. The report was considered by a round-table conference consisting of the delegates of British government of British India as well as of the rulers of the Indian states, inasmuch as the scheme was to unite the Indian states with the rest of the India under a federal scheme. A white paper prepared on the results of this conference was examined by a joint select committee of the British Parliament, and the Government of India bill was drafted in accordance with the recommendation of the select committee and passed with certain amendments as the Government of India Act 1935. Now, communal award. Before analyzing the main features of the system introduced by this act, it should be pointed out that this act went another step forward in preparing the communal cleavage between the Muslim and non-Muslim communities by prescribing separate electorate on the basis of the communal award, which was issued by Mr. Ramsay MacDonald, the British Prime Minister, on August 4, 1932, on the ground that the two major communities had failed to come to an agreement. From now onwards, the agreement between the two religious communities was continuously hoisted as a condition precedent for any further political advance. The Act of 1935, it should be noted, provided separate representation not only for the Muslims but also for the Sikhs, the Europeans, Indian Christians and Anglo-Indians, and thus created a serious hurdle in the way of building up of national unity, which the makers of the future constitution found it almost insurmountable to overcome even after the Muslims had partitioned for the separate state. The main features of governmental system prescribed by the Act of 1935 were as follows: federation and provincial autonomy. While under all the previous Government of India Acts, the Government of India was unitary, the Act of 1935 prescribed a federation taking the provisions of the Indian states as units, but it was optional for the Indian states to join the federation. And since the rulers of the Indian states never gave their consent, the federation envisaged by the Act of 1935 never came into being. But though the part relating to the federation never took effect, the part relating to provincial autonomy was given effect to since April 1937. The Act divided legislative powers between the provincial and central legislatures, and within its defined sphere, the provinces were no longer delegates of the central government but were autonomous units of administration. To this extent, the Government of India assumed the role of the federal government vis-a-vis the provincial government, though the Indian states did not come into the fold to complete the scheme of federation. The executive authority of the province was also exercised by a governor on behalf of the crown and not as a subordinate of the governor general. The governor was required to act with the advice of ministers responsible to the legislature. But notwithstanding the introduction of provincial autonomy, the Act of 1935 retained control of the central government over the provinces in a certain sphere by requiring the governor to act in his discretion or in the exercise of his individual judgment in certain matters. In such matters, the governor was to act without ministerial advice and under the control and directions of the Governor General, and though him of the Secretary of State. Diarchy at the center. The executive authority of the center was vested in the Governor General on behalf of the Crown, whose functions were divided into two groups: the administration of defense, external affairs, ecclesiastical affairs, and the tribal areas was to be made by the Governor General in his discretion with the help of councillors appointed by him, who were not responsible to the legislature with regard to the matters other than the above reserved subjects. The Governor General was to act on the advice of Council of Ministers who were responsible to the legislature. But even in regard to this latter sphere, the Governor General might act contrary to the advice so tendered by the ministers of if any of his special responsibilities was involved. As regards the special responsibilities, the Governor General was to act under the control and discretion of the Secretary of State. But in fact, neither any councillors nor any council of ministers responsible to the legislature came to be appointed under the Act of 1935. The old Executive Council provided by the Act of 1919 continued to advise the Governor General until the Indian Independence Act 1947. The legislature, the central legislative, was bicameral, consisting of Federal Assembly and Council of States. In 6 of the provinces, the legislature was bicameral, comprising a legislative assembly and the legislative council. In the rest of the provinces, the legislature was unicameral. The legislative power of both the central and provincial legislatures was subject to various limitations, and neither could be said to have possessed the features of the sovereign legislature. Thus, the central legislature was subject to the following limitations. Apart from the Governor General's power to veto, a bill passed by the central legislature was also subject to veto by the Crown. The Governor General might prevent discussion in the legislature and suspend the proceedings in regard to any bill if he was satisfied that it would affect the discharge of his special responsibilities. Apart from the power to promulgate ordinances during the recess of the legislature, the Governor General had independent powers of legislation concurrently with those of the legislature. Thus, he had the power to make temporary ordinances as well as permanent acts at any time for the discharge of his special responsibilities. No bill or amendment could be introduced in the legislature without the Governor General's previous sanction with respect to the certain matters. As example, if the bill or amendment sought to repeal or amend or was repugnant to any law of the British Parliament extending to India or any Governor General's or Governor's Act, or if it sought to effect matter as respects with which the Governor General was required to act in his discretion. There were similar letters on the provincial legislature. The instruments of instructions issued under the Act further required that bills relating to a number of subjects, such as those derogating from the powers of the High Court or affecting the permanent settlement, when presented to the Governor General or a governor for his assent, were to be reserved for the consideration of the Crown or the Governor General, as the case might be. Distribution of legislative powers between the center and the provinces. Though the Indian states did not join the federation, the federal provision of the Government of India Act 1935 were in fact applied as between the central government and the provinces. The division of legislative powers between the center and the provinces is of special interest to the reader in view of the fact that the division made in the Constitution between the Union and the states proceeds largely on the same lines. It was not a mere delegation of powers by the center to the provinces as by rules made under the Government of India Act 1919. As already pointed out, the Government of India Act of 1935 itself divided the legislative powers between the central and provincial legislatures, and subject to the provision mentioned below, neither legislature could transgress the power assigned to the other. A threefold division was made in the Act. There was a federal list over which the federal legislature had exclusive powers of legislation. This list included matters such as external affairs, currency and coinage, naval, military and air forces, census. Second, there was a provincial list list of matters over which the provincial legislature and the executive jurisdictions, as for example, police, provincial public service, education. There was a concurrent list of matters over which both the federal and the provincial legislature had competence, as for example, criminal law and procedure, civil procedure, marriage and divorce, arbitration. The federal legislature has the power to legislate with respect to matters enumerated in the provincial list of the proclamation of emergency was made by the Governor General. The federal legislature could also legislate with respect to a provincial subject if the legislature of two or more provinces desired this in their common interest. In case of repugnancy in the concurrent field, a federal law prevailed over the provincial law to the extent of the repugnancy. But if the provincial law, having been reserved for the consideration of the Governor General, received his assent, the provincial law prevailed notwithstanding such repugnancy. The allocation of residuary power of legislation in the Act was unique. It was not vested in either the central or the provincial legislature, but the Governor General was empowered to authorize either the federal or the provincial legislature to enact a law with respect to any matter which was not enumerated in the legislative list. It is to be noted that dominion status, which was promised by the Simon Commission in 1929, was not conferred by the Government of India Act 1935. The circumstances leading to the enactment of the Indian Independence Act 1947 will be explained in the next chapter, but the changes introduced by this act into the structure of government pending the drawing up of the Constitution for Independent India by Constituent Assembly should be pointed out in the present context, so as to offer a correct and comprehensive picture of the background against which the Constitution was made. In pursuance of the Indian Independence Act, the Government of India Act 1935 was amended by the adaptation order both in India and Pakistan in order to provide an interim constitution to each of the two dominions until the Constituent Assembly could draw up the future constitution. The following were the main results of such adaptations: abolition of the sovereignty and responsibility of the British Parliament, as has been already explained by the Government of India Act 1858. The Government of India was transferred from the East India Company to the Crown. By this act, the British Parliament became the direct guardian of India, and the office of the Secretary of State of India was created for the administration of Indian affairs, for which the Secretary of State was to be responsible to Parliament. Notwithstanding gradual relaxation of the control, the Governor General of India and the provincial governors remained substantially under the direct control of the Secretary of State until the Indian Independence Act 1947, so that in constitutional theory, the Government of India is a subordinate official government under His Majesty's government. The Indian Independence Act altered this constitutional position root and branch. It declared that with effect from the 15th August 1947, referred to as the appointed day, India ceased to be a dependency and the suzerainty of the British Crown over the Indian states, and the treaty relations with tribal areas also lapsed from the date. The responsibility of the British government and Parliament for administration of India having ceased, the office of the Secretary of State for India was abolished. The Crown no longer the source of authority. So long as India remained a dependency of the British Crown, the Government of India was carried on in the name of His Majesty. Under the Act of 1935, the Crown came into further prominence owing to the scheme of the Act being federal, and all the units of the Federation, including the provinces, drew their authority direct from the Crown. But under the Independence Act 1947, neither of the two dominions of India and Pakistan derived its authority from the British Isles. The Governor General and provincial governors to act as constitutional head. The Governor General of the two dominions became the constitutional heads of the two new dominions, as in the case of the other dominions. This was in fact a necessary corollary for dominion status, which had been denied to India by the Government of India Act 1935, but conceded by the Indian Independence Act 1947. According to the adaptations under the Independence Act, there was no longer any executive council as under the Act of 1919 or councillors as envisaged by the Act of 1935. The Governor General or the provincial governor was to act on the advice of the Council of Ministers, having the confidence of the Dominion legislature or the provincial legislature. As the case might be, the word in his discretion, acting in his discretion, and individual judgment were affected from the Government of India Act 1935. Wherever they occurred, with the result that there was no sphere in which these constitutional heads could act without or against the wishes of the ministers. Similarly, the power of the Governor General to require governors to discharge their certain functions as his agents were deleted from the Act. The Governor General and the governors lost extraordinary powers of legislation so as to compete with the legislature by passing acts, proclamations, and ordinances for ordinary legislative purposes, and also the power of certification. The governor's power to suspend the provincial constitution was taken away. The crown also lost its right of veto, and so the Governor General could not reserve any bill for the signification of His Majesty's pleasure. Sovereignty of Dominion Legislature. The central government of India, composed of the Legislative Assembly and Council of States, ceased to exist on August 14, 1947 from the appointed day and until the constituent assemblies of the two dominions were able to frame their new constitutions and new legislatures were constituted thereunder. It was the constituent assembly itself which was to function also as the central legislature of the dominion to which it belonged. In other words, the constituent assembly of either dominion until it itself desired otherwise was to have a dual function, constituent as well as legislative. The sovereignty of the Dominion legislature was complete, and no sanction of the Governor General would henceforth be required to legislate on any matter, and there was to be no repugnancy by reason of contravention of any imperial law. All about the historical backgrounds of our constitution. धन्यवाद, नमस्कार।